There's some bad court decisions, and then there is completely ignoring case law to do the bidding of anti-gunners and anti-gun politicians. So let's go ahead and talk about that. What's up, Wolverines, and welcome back to the channel. Today we're going to be talking about a case known as Hartford v. Ferguson, and it was brought by the Firearms Policy Coalition and the Second Amendment Foundation against Washington State that passed a so-called assault weapons ban that bans those scary semi-automatic firearms. And we're going to be talking about what this judge in the case said, which goes against case law, and it shows that he is an advocate for anti-gun stuff by denying SAF's and FPC's motion for a preliminary injunction. Okay, before I start harping on this judge's terrible decision, let's go ahead and talk about the case. The case was brought by two gun rights organizations and several citizens challenging Washington State's assault weapons ban. And I will always say with quotation marks, even if you don't see my finger quotations, just imagine I'm doing finger quotations, because the term assault weapons is a made-up term just to scare the people. But that is neither here nor there. Maybe I'll do a video in the future about the history of that term, which is quite interesting. Okay, so the plaintiffs claim that the state was violating its citizens' right to bear arms, and not only that, but since AR-15s are in common use, that the state could not ban them. This whole entire law was to ban AR-15s, even though that long gun deaths in all, including shotguns and bolt-action rifles, is far less than people actually getting strangled in blankets, which is an actual fact, by the way. They also claim that there's no historical analogs to show that this ban is constitutional. In the landmark Heller decision, the Supreme Court said any arms that are in common use cannot be banned by the government. And then we go over to Bruin, where they say that a law has to show that it has a historical analog. It has to be in the tradition, text, and history of the Second Amendment, or it is unconstitutional. So let's see what this judge did. The judge is named Judge Bruin, and he was appointed by Ronald Reagan, which says that he's been on the bench for a very, very long time. The judge said that the state could ban AR-15s because they are not in common use for self-defense. Heller never said anything about self-defense. Heller said common use. This judge added self-defense to it because since the AR-15 is the most popular rifle in the country and is known as the modern musket, he knew if he used the term common use just applied to the AR-15, he would never ever be able to say that the state was right in banning them. So right there, he tries to do some legal jujitsu to get around the term common use by adding in self-defense at the end. It's bad enough misconstruing the Heller decision, and it's either that he didn't know what the Heller decision said or chose to ignore it. And I am thinking that he chose to ignore it because what he did in relation to the Bruin decision. The Bruin decision said that any law has to be in line with the Second Amendment from the founding era. It has to be in line with the actual text, tradition, and history of the Second Amendment from the founding era. And there's no such thing as intermediate scrutiny anymore when it comes to Second Amendment cases. That is interest balancing. That's the interest of the state versus the rights of the people. Judge Thomas said you cannot apply that to a Second Amendment case because the Second Amendment is not a second-class right. So what did Judge Bruin do? He did interest balancing, which is totally against what the Supreme Court said in the Bruin decision. He balanced the interests of the state versus the interests of the people. He tried to say that AR-15s are inherently dangerous and that it is the right of the state to ban them because they have the interest to promote public safety, which I can disagree on many different levels there, but it doesn't even matter because the state has to show historical analogs, and they're not allowed to use interest balancing in their lawmaking, which this judge went ahead and applied interest balancing to this case. And you cannot tell me that he's not aware of the Bruin decision. I am positive he's read the Bruin decision, and I am positive he knows what it said. In fact, the Second Amendment Foundation and Firearms Policy Coalition actually referenced Bruin in their arguments. He also tried to shift the burden of proof from the state to the plaintiffs. The way it's supposed to work is that the state is supposed to prove in a court of law that their law is constitutional. It's not supposed to be the other way around. The state is supposed to come in there with historical analogs and examples of how their law falls in line with the text, tradition, and history of the Second Amendment during the founding era, which is the 1700s, 1791. And the state didn't do that, but the judge said that the plaintiffs have to prove the law is unconstitutional, and the state doesn't have to prove that the law is constitutional, which is ass backwards. That's not the way it's supposed to be. It is very hard to prove a negative. What we are seeing here is a case of judicial advocacy. This judge is being an advocate judge for the anti-gun side. Judges are supposed to be bound by decisions made at the Supreme Court, and this judge is outright ignoring the Supreme Court and ruling on this case like the Bruin decision never happened. So FBC and SAF got their preliminary injunction denied by an advocate judge. Does this mean that they will lose going forward? No, not at all. I think that they will actually win going forward because not every judge is an advocate judge. It's just a little setback on the road to victory, which will happen. There will be setbacks. There will be battles lost, but there will be more battles that are won, and we are seeing those battles being won across the country. This is just one advocate judge that cannot bring himself to do his job and is doing the bidding of the anti-gun, anti-freedom, anti-liberty groups like Everytown, Giffords, and Brady. This judge should not be on the bench if he does not want to rule by using U.S. law and U.S. case law. He should retire, because if he doesn't agree with the decisions of the Supreme Court, that is fine, but he is still bound by what they say. All right, guys, I'm going to get off here before I go Crump smash mode. I am very, very, very close to getting to that point, and I don't want to get to that point today. I know you guys would find it entertaining, but I want to have a good day. Namaste, namaste, namaste. And I want to go do some fun stuff, which I haven't been able to do in a while. So I'm going to go do some fun stuff and relax. But advocate judges really, really pisses me off, and Judge Brian pisses me off royally. I'm going to give you a secret link, and that's crumpy.com/BSP. That's crumpy.com/BSP. Go there, find out what it is, and you can support the channel by going there as well and buying a John Wick head or a Cobra Commander head. I guess I just gave out what it is, but go check it out anyway. I would appreciate it. Okay, guys. Love you very much. Stay ever vigilant. Stay ever free. Like, comment, subscribe to the channel to help me grow. I want to hit 45,000 relatively soon, and you guys can make that happen. All right, guys. Wolverines, motherfucker.